Hello guys, welcome back to my channel. It's your favorite lawyer again. So today we're looking at understanding writ in Nigeria, understanding how civil cases start in Nigeria. First off, when someone wants to commence a civil action, a civil lawsuit in Nigeria, for instance, a contract matter, you have an agreement with somebody to supply goods to you, or you're the recipient, or you're even the supplier and you supply, the person did not take, the goods have gotten spoiled or stuff like that. Once has to do with a contract, or once has to do with a tort, that is a legal wrong like a defamation, or that is defamation or libel or slander, whichever one, defamation, or even like a malicious damage to your property. So when it's a civil action, it is not a criminal action. The modes of instituting that legal action in court is what we are looking at today. And the writ is one of the forms of instituting a civil action in court. So we're looking at writ, but let's start by establishing that there are four ways to institute a legal civil action in court in Nigeria. So the four ways are by writ, the second is originating summons, the third is petition, and the fourth is originating motion. So out of these four modes of instituting civil legal actions in Nigeria, writ is the most popular and is the more general one. The other modes are quite specific and tied to very restricted uses. That's the three other modes. So the writ of summons is the most popular one, and that's what we're going to be looking at today. So a writ is the formal document that the plaintiff or claimant will use to commence the case. By taking out these documents in court, the claimant or plaintiff will serve it on the defendant, that's the other party to the suit. So a writ is a formal document that commences a case and notifies the other party whom the case is against of the pendency of that matter in court. So in what cases is a writ of summons used? Now, a writ of summons is used where the matter is contentious. That is, there will be a need to call witnesses and go into trial. So a writ of summons is used in those kinds of circumstances. Remember that I said at the beginning that there are four modes of instituting civil actions in Nigeria. And I said that the modes are dependent on the nature of the claim. So it depends on what the issue is about. It depends on the facts of the case. It depends on the story. It depends on what transpired. That will determine what mode of action that you will take. If it's a contentious matter, like I gave an example at the beginning, I said there's a contract and there's a dispute, then of course there will be need to bring in evidence and there will be need for trial. So the court will now have to hear the testimony of the two parties. That is their evidence, the testimony or the evidence, whether written or oral testimony. But the court will need to examine them. And usually there's a right of cross-examination. Cross-examination means that the claimant will ask the defendant questions while the defendant is in the witness box. And the defendant will also ask the claimant questions while the claimant is in the witness box giving the testimony. So where all these were envisaged that there will be trial, there will be need to hear the witnesses and cross-examine them, then most likely that matter will have to be commenced by means of a writ of summons. This is as opposed to an originating summons, which is the second form of instituting legal civil actions in court. Originating summons are used where the matter is not contentious, especially where you want the court to determine and explain or give interpretation to a document. So let's say you take a document to the court and you ask the court to determine what this document really means. To give an interpretation, let's say the two parties have an argument as to the interpretation of a law or a document. The court will now take the matter to court through originating summons, because there's not going to be any trial. You're not calling witnesses into this. It's for the court to give interpretations to documents. Like that's why I stated that for writ of summons, the matter will be contentious and will require the use of witnesses. Furthermore, the third form of instituting civil actions in court in Nigeria is by way of petition. But petitions are strictly used for very specific matters that the law has required that those matters have to be brought by means of petition. So you can see that the first two forms of instituting civil actions in court in Nigeria are the broadest forms, because the writ is for generally contentious matters, while the originating summons are for non-contentious matters. Then the petition is for very specific matters that the law has provided that those specific matters will be instituted by means of petition. And the two common cases where petitions are used are for divorce proceedings or anything about matrimonial proceedings. They are done by way of petition, particularly with respect to divorce proceedings and also election matters. Then the fourth form of instituting legal civil proceedings in court is by way of originating motions. Now, for originating motions, there's a similar requirement as is with petitions, because for you to come by means of an originating motion to court, it means that the law or the rules of the court have provided that such applications can be brought by means of originating motions. So they're also not for matters that will go into full trial. So basically, a writ is the main form of instituting a civil legal action in court, particularly matters that are contentious and where witnesses will need to be called. While the originating summons, as opposed to the writ of summons, is just used to ask the court to interpret or clarify certain provisions of either a contract or a document or a law. Now, looking at examples, a writ can be used in the case of a breach of a contract. A writ can be used in the case of defamation, either libel or slander. A writ can also be used for land disputes or trespass. Another example is for cases involving negligence or torts generally. So these are examples and instances in which writs can be used. We'll now go into what a writ should contain. So a writ has to contain some vital information, without which the writ may be defective. So the first thing you see on a writ is the name of the court. The heading will be the name of the court, so that you even know which court is summoning you as a defendant in that action. Then, of course, the names of the parties. You need to know which parties are involved in that suit. Then you typically see the lawyer who has taken out the writ on behalf of the claimant or the plaintiff, the lawyer's full names and address. And of course, the lawyer's signature has to also be on the document. Typically, too, you will see the stamp on the signature of the court registrar. That is the court that has endorsed the writ. You will see the details of the court. You can't just see only the heading of the court that is just typed on the document. You have to see that the court actually endorsed the writ, because there will be a signature from the court, usually with the court stamps, signifying that the writ has been duly taken out in court. Then the writ will also contain a short description of what the claim is about, and it will contain the time frame in which the defendant is supposed to enter into appearance, that is, come to court to acknowledge that the suit has been served on the person. That time frame is usually stated there, and it varies depending on the courts in the different states in Nigeria. So typically, with respect to state high courts, each state high court in Nigeria has the rules of court, and it's the rules of court that will govern all of these things. Then the documents that will accompany the writ are the statements of claim. Note that the writ just has a summary of what the issue it's about, but the writ will now be accompanied by further documents, and those documents are now the statement of claim. That is the document that states, as the name implies, the entire claim that the claimant or the plaintiff is seeking in court. So the statement of claim will tell the story that the claimant has and say what wrong or what the person's grievance, that why the person has brought the defendant to court. And it will also have the reliefs that the claimant or plaintiff seeks from the court. And so this statement of claim usually accompany the writ. Other documents that also accompany the writ will be the witness statement on oath. That is the statement of the witnesses in that that will support the claimant's case. So initially, years back, the witnesses just come to court, state their testimony in court. But to save time and for faster dispensation of justice, this testimony of the witnesses are now front loaded. That means you capture it ahead of time, not when the matter starts, when the trial starts and the witness comes to court to start telling the entire story afresh, and then the court has to start recording and writing everything down by hand. But now the story or the testimony of the witness will be captured in writing. So that's why it's called a written statement on oath. And note that that statement on oath, as the name signifies, is not just an ordinary statement, but is one that is made on oath. So it's as if you have sworn to it, just like you will swear to it in court. But note that you will still come to court as a witness to adopt what you have said in your statement on oath, and so that the defendants can now ask you questions. That is the cross-examination. So it doesn't mean that the witness will not still come to court because the documents have been front-loaded. No, the witness will come to court, adopt the statement on oath that has been front-loaded ahead of time, and the witness will now stay in the witness box and answer questions that will be put across by the other party or the other party's lawyer. Also, the writ of summons be accompanied by the list of witnesses and the list of documents that the party wants to rely on. So typically, this is what a writ looks like, what a writ should contain, and the documents that accompany the writ. We'll now talk about serving the writ. That is the service of the writ. Like I alluded to earlier, the writ is the document that the person who is taking the matter to court starts with. And so once a litigant, a claimant or plaintiff has taken this matter to court by taking out this writ, the next thing is to serve it on the defendant. Else, how will the defendant know that a matter has been taken against him in court? So typically, in the interest of dispensing justice, the rules of court have provided these other forms of alternative means of service. Otherwise, ordinarily, service of a writ should be done personally on the party that is involved. That is, you hand it over to a person if it's a person, or to the officers of a company if it's a company. But like I said, in situations where the defendant is on the run and wants to avoid all of that, it doesn't mean that the claimant will not get justice. So these other means of service can now be explored. However, you have to also go back to court to get the leave of court, that's the permission of court, to serve the defendant by these other means. So the initially approved means is by personal service. But where personal service cannot be made, the claimant will approach the court and get the court's consent, the court's leave, to serve the defendant by any other means that the claimant deems necessary. So we'll look at why a writ matters. One of the reasons a writ matters is because once a writ has been properly taken out and served, it officially marks the commencement of a lawsuit. So the writ has evoked the decision of the court. And even if the claimant or the plaintiff wants to withdraw the action, he cannot just go and sit down just like that. He has to properly withdraw the action. Although, yes, if they don't show up, the court can eventually strike out the matter. But the important thing is that you have evoked the court's jurisdiction into that matter by taking out a writ properly, filing it, and serving it on the defendant. The third reason why a writ is important is that once the matter has been successfully commenced by taking out the writ that has now been filed and served on the defendant, then the statute of limitation stop running at that time. We can look at statute of limitation in another video, but I'll just explain that the law provides that for some matters, the action has to be brought within a certain time frame. Typically for contracts, if you have a dispute with another person over a contract, you have 6 years to bring in that matter to court. So if your 6 years have elapsed, you can no longer bring that case to court. It's called statute barred, because the statutes, that the laws, have barred you from bringing a lawsuit. So that is what we call statute of limitation. That is the laws that talk about limitation, where you are limited. You can no longer bring actions after some certain time. So the statute of limitation provides for different cases and the time in which they have to be brought. So even though the law wants to promote justice, the law doesn't aid an indolent person. So if you have taken out a writ, the time stops running at that time. If for any reason the matter doesn't go on and the case is struck out, let's say, like I said earlier, the claimant did not really come back again to court and the court struck it out, your time continues running from that time the matter was struck out. And once your 6-year period elapses, you can no longer bring the matter to court. So this is why a writ is important, because it helps to calculate the status of limitation, and it tells you the time frame within which you can bring a matter to court or not. So in summary, a writ is what gives life to a civil law action. And so if it is not taken properly, or if a writ is faulty, it can affect the entire case, no matter how good the case is. So this is why you need to always engage a specialist before you take out a writ in court, so that you don't blow up your chances of getting justice from your good case. This is why I'll be wrapping up this video. Please, I encourage you to ask your questions in the comment section below, and also please do well to like this video and subscribe to the channel so that you can get more videos as we continue to do more videos to enlighten you. So I hope you got value from this video. I'll see you in my next video. Bye.